Approval of consent agenda. All in favor?
Aye.
Opposed? The ayes have it. Consent agenda is approved. Okay, Melissa, your show.
Yes, sir. Item 5 on the agenda is public comment. Members of the public are invited to address the Board of Commissioners on any topic. Public comment is not intended to require the board to answer any impromptu questions or take any action on items brought up during this period. Speakers will address all comments to the board as a whole and not one individual. Discussions between speakers and members of the audience will not be allowed. Time limits are 3 minutes per person or 5 minutes per group. Please come forward to the lectern and identify yourself so your statements can be recorded.
All right. Anyone like to be heard?
Can you hear me okay? Hear me okay?
Yeah.
Good evening. I'm Yvonne Farmer, and my husband Mike and I reside at 127 Peninsula Drive. I'm speaking on behalf of my neighbors who are concerned citizens living in the peninsula. Because the topic came up so quickly for tonight's agenda, most of them are out of town on vacations, weddings, or work, so they wrote letters for tonight's hearing. Also, the Peninsula Owners Association owns community assets immediately adjacent to the Salt Meadow Landing property. Our organization was not notified of tonight's meeting. We learned about it well after adjacent property owners were notified. We feel we are parties with relevant evidence and respectfully ask that those letters be read out loud at the appropriate time to be included as testimony in the quasi-judicial hearing. I have hard copies of those letters with me. After reviewing the town's meeting agenda packet, we believe there's a serious error in the document. The special use permit application states it is limiting its residential dwelling unit request to the 22-unit maximum, but the drawings in the agenda packet show 44 units. Staff states that the proposed site plan meets the standards of the ordinance, which clearly a 44 residential unit plan does not. What set of plans are being considered for the special use permit? I'm confused. Is it 22? Is it 44? What businesses will occupy the commercial space? Will there be a restaurant or not? Maybe, maybe not. What does it look like? Does it conform to the Manteo way of building? Who knows? Nothing seems to be locked down. And given the apparent erroneous information provided to the public, a better course of action would be to delay or continue the quasi-judicial hearing to another day after firm plans are provided for the public to review. Let's remember that the B3 zoning ordinance is their one and only entrance district. I repeat, one and only entrance district, the area everyone will see first when they come to our special island. A lot of input from citizens and local leaders were put into developing a comprehensive plan. The comprehensive plan states for our entrance district, permitted uses approved by the zoning administrator, single-family detached residence only, uses approved by the Planning and Zoning Board, home occupations, temporary structures, accessory dwelling units, automobile parking lots. That is what the entrance district was intended to be. Think about it. It was intended for single-family homes. Now this brings us to why we're here discussing this today. There's been a special use or exception for the entrance. There has to be a special use or exception for the entrance to be used for anything different. I repeat, anything different. But it takes the commissioners to agree to that exception. Multifamily units and commercial spaces are not automatically approved for the entrance district. So the original authors of the comprehensive plan put this special provision in the plan to give you pause. Pause to make you think and really study long and hard if it's really what you want at the entrance to our historic island. We have a beautiful Sarah B. Owens Visitor Center at our west entrance that honors someone that was a dear friend of mine and a very gracious lady. Don't you want something at the east entrance that looks just as good? I remember when Kitty Hawk Land Company developed Marsh's Light, the mayor, town manager, and commissioner stood firm and were adamant about making the developer conform to the comprehensive plan. As a result, Marsh's Light is a residential development in downtown Manteo that we can all be proud of. The result of your decision today will be your legacy. If approved, then as everyone enters historical Roanoke Island, will they say, the mayor, town manager, and commissioners stood firm and made the developer accountable? Or everyone say, what a mess. It looks awful and traffic is even more of a nightmare. What were they thinking? In closing, I'll touch on some key concerns that you've heard over and over again. First and foremost, traffic safety is an issue. This problem must be resolved before North Carolina Department of Transportation permits any new construction. Secondly, stormwater runoff and road flooding is another significant concern along Russell-Clyford Road, and the developer should be required to pay for all stormwater management remediation that may result to adjacent properties. Third, the developer should be required to demonstrate that there is an underserved demand for commercial property and have a clear written disclaimer that the property owners are not permitted to convert unused commercial space into residential dwellings. Finally, if you approve a special use permit, that there be a time limit on it, that be valid only for a specific time period to validate conditions that have been met and maintained by the applicant. I urge you to make a decision in the best interest of the town of Manteo and its residents and homeowners, and not to feel pressured to deviate from Manteo's thoughtfully developed B3 zoning ordinance from a developer seeking to maximize their profits. Any development at the entrance of Manteo should enhance the attractiveness of our lovely town, not increase traffic safety concerns, and be fully compliant with all existing zoning ordinances. Full stop, no exceptions. What is that slogan? Just say no? Thank you.
Thank you, Ms. Farmer. Anyone else? Would anyone else like to be heard? We will now close public comment period. Okay, Melissa.
Mr. Mayor, item 6 on your agenda is a quasi-judicial hearing for Salt Meadow Landing special use permit application, and I am going to turn it over to the town attorney.
The purpose of this quasi-judicial hearing is for the board to determine whether or not a special use permit should be granted to Salt Meadow Landing OBX LLC. And please bear with me. I'm going to read through a number of things that give the board and the audience and the applicant a reminder of what the standards are and what...
Ben, do you mind just picking up a little bit?
No, sir. I'll be glad to
Thank you
speak
so
up
much.
as much as I can.
Thank you.
Please allow me to provide a brief overview of the quasi-judicial hearing process for those who may not be familiar with it, and as a reminder to those who are familiar. In reviewing a SUP application, the Board of Commissioners is a formal quasi-judicial board which operates under strict rules and procedures which are set forth by statute in a fashion similar to a court of law. The board's decisions must be based on substantial, competent, and material factual evidence presented under oath at this hearing. While the board is not strictly bound by the courtroom rules of evidence, they are guided by those rules and the general statutes as to what evidence is admissible. Hearsay, generalizations, speculation, and most lay witness opinions may be subject to objections, precluding them from being considered in the board's decision-making process. Lay witness opinions on matters such as traffic, land valuation, and other issues that typically require expert witnesses are statutorily not competent evidence. Only qualified expert witnesses may provide competent testimony on such matters. In that regard, we ask that witnesses restrict their testimony to only factual information that is relevant to the limited issues under consideration. Testimony by all witnesses must be given under oath or affirmation. All witnesses must go to the lectern and identify themselves in order to provide their testimony. No other discussion by the audience is allowed. Any physical evidence presented will be made an official part of the proceedings and will be retained by the board. The initial parties are the applicant and the town. Parties may object to testimony and cross-examine one another's witnesses and members of the general public who provide testimony. Parties will be provided an opportunity for brief closing arguments. Questioning, objections, and argument must come from your attorney or the applicant themselves, not someone appearing for them, such as an engineer, architect, or surveyor. Absent the granting of a formal motion to intervene, no members of the general public may question witnesses, make objections, or make arguments to the board. It's imperative that no member of the board participate in or vote in any quasi-judicial matter in a manner that would violate an affected person's constitutional rights to an impartial decision-maker. Impermissible violations of due process include, but are not limited to, 1, having a fixed opinion prior to the hearing on the matter that is not susceptible to change, undisclosed ex parte communications, and 3, having a close familial business or associational relationship with an affected person or financial interest in the outcome of the matter. Previously undisclosed ex parte communications which have not caused you to develop a fixed opinion may be cured through the disclosure of the facts or information obtained on the record. There have been some emails that I know the board members have received. Ms. Dickerson has provided those to the applicant and made them a part of the agenda packet. While you shouldn't necessarily consider them as part of your decision-making process tonight, I believe that cures the undisclosed ex parte communications issue, unless you have other undisclosed communications that you need to disclose. A party or a member of council, including the council member at issue, may object to any member's participation for lack of impartiality. If an objection is raised to a member's participation and that member does not choose to recuse himself or herself, the remaining members shall by majority vote rule on the objection. Other than what we mentioned already, do any of you have any conflicts which would potentially make you an impartial decision maker, or have any other undisclosed communications or information you would like to disclose at this time? Let me provide a quick roadmap of the process for this hearing. It's the town's intention to provide all parties to this hearing with the opportunity to cross-examine adverse witnesses and to offer evidence in support of their position and in rebuttal of their opponents. Because of this is an application for an SUP, the applicant will have the burden of making a prima facie showing that they meet the requirements of the town zoning ordinance in order to obtain the requested SUP. If this burden is met and not rebutted by a preponderance of competent contrary evidence, then the SUP ultimately must be issued to the applicant. Town staff will testify first in order to provide an overview of the application. Once staff has completed their evidence, the applicant will have an opportunity to provide evidence. That will be followed by the evidence of any other party. If there are any, then the general public will have an opportunity to provide evidence. The parties will then have an opportunity to provide brief rebuttal, and upon completion of the evidence, the parties will have an opportunity to make brief arguments summarizing their positions. The board may, but is not required to make a final decision tonight. The board will deliberate on the issues in the case and attempt to reach a decision whether to grant the SUP, deny the SUP, or grant the SUP with reasonable conditions. The board shall issue the requested special use permit unless they conclude, based upon the information submitted at the hearing, that 1, the requested permit is not within its jurisdiction, or 2, the application is incomplete, or 3, if completed as proposed in the application, the development will not comply with one or more of the requirements of this ordinance. The board may also deny the SUP if granting the SUP would be not be in conformity with the town's land use plan or the latest guidelines for development, or the proposed use will not be compatible with the area in which it's to be located. The relevant requirements are those found in Article Roman numerals 9 of the town's zoning ordinance for mixed-use residential above retail in the B3 entrance district where the property is located. Pursuant to Section 9-1B, the applicant must provide substantial competent evidence that the proposed development meets the following standards in addition to the relevant dimensional standards under Section 9-2. They must maintain or enhance the public health, safety, and welfare. They must maintain or enhance the value of adjacent property or be a public necessity. They must comply with the general intent of the B3 zone for physical development of the area. They must contribute architecturally to the traditional village-like atmosphere of the historic town, and they must comply with all other regulations contained in the zoning ordinance related to this particular use. The board may not rely on or use any part of the preliminary forum before the Planning and Zoning Board or the recommendation of the Planning and Zoning Board as a basis for its decision on the special use permit. The board may attach to the special use permit reasonable and appropriate conditions and safeguards. Conditions and safeguards imposed shall not include requirements for which the town does not have authority under statute to regulate, nor requirements for which the courts have held to be unenforceable if imposed directly by the local government, including without limitation, taxes, impact fees, building design elements within the scope of 160D 702B, driveway-related improvements in excess of those allowed in GS 136-1829 and GS 160A-307, or other unauthorized limitations on the development or use of land. Not hearing any motions or anyone who wishes to formally intervene, we'll now move to the hearing on the merits. All persons who expect to give testimony during the hearing today, please step forward. And Ms. Whitley will swear you in. We'll now open the evidentiary portion of the hearing. And Ms. Dickerson, if you'd like to move forward with the town's evidence.
Thank you, Mr. Gallup. Staff are in receipt of an application for a special use permit for Salt Meadow Landing development submitted by Salt Meadow Landing OBX LLC. The special use permit application, attachment 1, special use permit application is for a mixed-use development. I got it. Yeah. Is for a mixed-use development with commercial space and 22 dwelling units located at 0 Russell Twyford Road, Dare County parcel 0258-20000. I'd like to offer the following exhibits for the record, and I have just provided the applicant with these exhibits. Exhibit A is the staff report and attachments published with this meeting's agenda packet with the corrected site plan. Exhibit B is the August 2nd, 2022 email and its attachments received by Melissa Dickerson from Mr. Strader. Exhibit C is the July 29th, 2022 email and its attachments received by Melissa Dickerson from Mr. Gupta regarding the adjacent property owner and easement. Exhibit D are the emails sent to the Manteo Board of Commissioners. Adjacent property owners were notified by first-class mail of the application on July 6, 2022 and July 27, 2022. Public notices of the quasi-judicial hearing were posted in the Coastland Times on July 17th and July 24th. There was also notifications posted on the property. On December 7th, 2021, Planning Department staff reviewed the site plan for the following members. Of course, the site plan has evolved as the process has moved forward over the last several months. The town manager, the water and sewer director, public works director, building inspector, and fire marshal. The following are comments from the staff at the time in December, and of course the applicant has responded to many of these. The first was construction site needed for each facility, class 1 through 6, in order to determine the fire flow using the ISO method, list of sprinkler protected facilities versus non-sprinkler protected facilities. Number 3 is the proposed fire hydrant distribution, which the applicant did address. 4 was fire access roads meeting the turn radius requirements and support the weight loads of the largest Roanoke Island Volunteer Fire Department. The staff worked with the engineering firm to get the turn radius from the fire department, and those have been addressed. Number 5 was to label the fire access lane, no parking fire lane. That was addressed. Note number 6 is based on the topo data on the site plan was outdated but has been updated since then. Number 9 was a question about whether or not these would be rental or sale units. 8 was another note about the topography data. Note number 9 was a question regarding if the 6 dumpsters provided on the site plan were sufficient for this development. 10 is that a stormwater permit would need to be maintained from the state of North Carolina. 11 is that CAMA permits would need to be obtained. 12 was regarding sewer calculations that has been updated. 13 is a note that utilities are to be privately owned and maintained by the developers. Number 14 were some notes that were not legible, specific to the trees in the 50-foot buffer in the Virginia Dare corridor, and those that area has been updated on the more recent landscaping plan that staff received yesterday from Mr. Strader. Number 15 was a question regarding the easement that existed with the adjacent property owner, and it did. The question was, did it convey? And it did when the property was purchased. And we have additional information related to that easement and the adjacent property owner later. The van accessible parking number needed to be relocated. That has been accomplished. Number 17 is that the North Carolina DOT encroachment permit or driveway permit will be required for utility work and for the driveway and roadway accesses. 18 was to show hydrants in nearby locations, and staff note that the hydrant locations could be improved, and they have. Number 19 was related to the town's water codes, water rate codes and schedule. On January the 11th, 2022, staff met with Mr. Gupta, Mr. Bob Hauser, and Mr. Michael Strader regarding the proposed Salt Meadow Landing. Staff received an email on March 10th, 2022 from North Carolina DOT stating that as part of their permitting process, they will require a traffic impact study. Staff recommended that the planning board also recommend a traffic impact study, and they have made that recommendation to you all as a potential condition of this permit. On June 21st, 2022, staff received the updated proposed site plan and document responding to staff notes. I will note that that day, and there was some confusion here. On June 21st, we received 2 emails from Mr. Strader. The first one was received at 3:37 p.m. With an application for 44 dwelling units. And then the other email was received at 3:49 with an application for 22 dwelling units. Those 2 site plans that coincided with the application were opposite of the application. So that is what has stemmed from the confusion of the site plan that was published having 44 units. We pulled the site plan from the application that said 22 units, and so that's caused a bit of confusion on staff end, but it is fixed at this point, and the large size site plan is available here. Staff met again with representatives from Saga on July 7th, 2022, and during that meeting it was noted that part of the driveway for this development is located outside the town of Manteo's planning jurisdiction. Staff have confirmed with Dare County and have provided that evidence to you this evening that the applicant has contacted Dare County about any necessary approvals required by the county. Staff recommended to the planning board that this matter be resolved prior to any approval of the special use permit by the Board of Commissioners, and that a letter from the property owner be provided to the town that they acknowledge that this roadway will count against their lot coverage and other zoning considerations relevant to Dare County. The applicant has provided a letter sent by their attorney to the adjacent property owners regarding the joint easement agreement, and provides notification that the applicant intends to install the improvements as called for in the agreement. Staff would like to note that buildings G and F are all commercial with no residential on the second or third floor. Staff noted at the planning board meeting that sheet 4, lighting and landscaping plan, lacked details related to the Roanoke Voyages corridor buffer area along Highway 64, and staff received an update from the applicant's engineer at 1 p.m. on Tuesday, August the 2nd, yesterday, with an updated lighting and landscaping plan. Staff were not able to review that as we were at that time preparing to host our annual National Night Out event. Those documents, though, are provided by the applicant's engineer can be found in the binders provided to the board and to the applicant, but they were not included in the agenda packet. At their July 12, 2022 meeting, the Planning and Zoning Board recommended approval of the special use permit application to the Board of Commissioners along with the following recommended conditions. The applicant obtain all necessary approvals by Dare County prior to the Board of Commissioners meeting and approval. The applicant obtain and provide a letter to the town from the neighboring property owner, Dare Development, acknowledging that the roadway will count against their lot coverage and other zoning considerations relevant to Dare County prior to the Board of Commissioners meeting or approval. That the applicant improve the landscape and lighting plan to include a similar uniform buffer as the neighboring CVS along Highway 64 and along Russell Twyford Road prior to the Board of Commissioners meeting and approval. That the applicant complete a traffic impact study and receive approval by DOT and make all necessary recommendations made by the Preservation and Architectural Review Committee. Exhibit D includes communications received by the Board of Commissioners and disclosed for the purpose of this quasi-judicial hearing. The emails may or may not be considered as competent evidence during the course of the hearing. The applicant has received electronic and hard copies of these exhibits and emails. That concludes my remarks at this time.
Do any members of the board have any questions for Ms. Dickerson?
How many conditions have the applicant met so far? At least 4 or 5 you said that the Board of Planning and Zoning recommended.
Well, so the first one was approvals by Dare County. I'm satisfied with the email exchange that the applicant's engineer has had with the county, that they are that they would move forward with approval of the driveway, the half of the driveway. The letter that we have included as an exhibit that we received from Mr. Gupta, I believe it was Friday, from his attorney to Dare Development, which is the adjacent property owner. That is not exactly what the planning board had recommended, but it does indicate that the applicant has made some effort to notify the adjacent property owner. The landscaping plan was provided yesterday. Again, we were out of the office when it was received, so we haven't had a chance to review that.
Okay, how about
The traffic impact study, it's my understanding that the applicant has engaged in some manner, and perhaps they could elaborate later, with a traffic engineer pursuing that kind of study. And then, of course, the review by the Preservation and Architectural Review Committee would come later, but the Planning Board has recommended that as a condition that you all could add to any approval that you would consider tonight.
Does the applicant have, or does anybody else on the board have any questions for Ms. Dickerson? Does the applicant have any questions for Ms. Dickerson? Seeing that there's no questions for Ms. Dickerson. Ms. Dickerson, is there any other staff testimony?
No, sir.
And Mr. Gupta, if you'd like to move forward with your case.
Good evening. I'm Sumit Gupta, representing the applicant. I appreciate your time tonight in consideration of our application. I also have Michael Strader with Quiable. He's here as well, standing by to answer any questions you may have. That's more technical. So I wanted to start by a brief history of how we got here to this application. We purchased this property with the intent initially, there were some initial approvals some time ago that they were approved. All local and state permits were approved. This is about 10, 15 years ago, to do, I think, 34 multifamily over commercial. And our intention was to do something similar because our engineer said all the current conditions, you still meet them. But instead, we had, if you recall, this has been about a year ago, we proposed a text amendment to allow for 72 apartments on this property and not do any commercial. Currently, this property allows up to 44 multifamily. If you take the inclusionary housing ordinance and apply that, you can do 22 market rate and 22 more affordable. It allows you to do commercial as well. So our intent for that application was to remove the commercial, do 72 just multifamily, and the purpose was really to try to address the housing needs here, or the long-term housing needs. That was not approved, the text amendment, which we were fine with. I think some of the reasons that were given at that were that, yes, there was an acknowledgement by the board that housing is needed in this area, but that it doesn't really fit the land use plan for the B3 entry, which promotes mixed use, commercial and residential, more from a village look. So it got denied, and we moved on from that, and to bring an application that would meet all the current rules. The current application has 22 multifamily units with commercial underneath. We did submit initially 2 applications to Melissa and the planning staff. One was for the 44 units that included 22 additional affordable units. After discussing with the town staff that just some requirements around there, and to keep things simple, we decided to remove those 22 units. So this application has 22 multifamily with commercial underneath it. We believe this application meets the current rules and ordinances, also complies with the zoning. The B3 zoning district promotes, I believe, what we're proposing here, residential over commercial retail space, basically a mix of uses. It specifically states that the B3 entry zone was established to allow for commercial activity with residential opportunities in areas that are entryways to the town. Further, it was intended to create a village-like atmosphere. The comments I have heard and also read from, I think it was mostly the people that live on Peninsula Drive. Melissa was kind enough to forward those emails to us to review. One of the main comments I see is around traffic issues. I want to point out that we still have to go through full site planning, engineering, state permits, additional local permits, and I believe DOT also wrote an email to Melissa saying they're going to require a traffic study. That's something we intend to do. And it's also a condition for the planning board. My understanding is that's not a condition, it's a condition as part of the SUP, not a prior to the SUP. But we completely understand that we have to do a traffic study, and as we get into further engineering. I don't live in the peninsula. The people that live there obviously know it the best and some of the traffic issues that come with it. I think that, I do know there's a lot of traffic issues all around the beach. When we go from, a population of 10 times in the summertime, and it exists in, just wanted you to consider, large parts of the beach. And it's a big difference. I'm not sure if it exists. I mean, I haven't seen it exist year-round But it's something, again, we're going to do a traffic study, and we agree with that condition if given the, granted the SUP. Another issue around it, the site plan has a cut-through that goes from the highway to Russell Twyford, and, you know, that does create another option for people to come in and out. So, you know, in some ways, there is a loop around there. Obviously, any development does add to traffic. That's just the nature of any development coming in. But, you know, that does give another option there. But again, we're agreeing to doing a traffic study as part of our next steps. Aesthetics, I saw a comment on aesthetics. Just important to note, we will go through the architectural review process, and we are aware of the Manteo Way. Again, there's a lot more steps that we have to go through in the architecture. We plan to do a first-class community. We understand that we have to work with the town. We have to go through the architectural review process in the Manteo Way, and that's all to come. There was a mention of stormwater. Again, we are required to go through all types of additional permits, state and local, including a stormwater permit from NCDEQ, and that will require us to maintain all runoff within our site. Mike Schrader certainly can add more to that, but the state has very strict rules around this. So another comment that stated, we do not know what the applicant's plan is, and the applicant is reluctant to offer details. Just want to address this right here. I'm not exactly sure where this is coming from, but we have a pretty clear site plan that we've submitted that we feel more than satisfies the conditions of the SUP. We are not seeking approval for construction, as there's many more steps available that are needed right now. For now, we have 22 multifamily units that are above the commercial and retail spaces. Another comment was made that, you know, who's going to occupy these commercial spaces? We do not know at this time, but whoever occupies these spaces, as we get further into this, they will have to meet what, you know, what is permitted within the code. With all that being said, we respectfully request an approval of our SUP application based on the facts that we do meet all the rules. We agree to the conditions set by the planning board. The B3 district promotes pretty much what we're doing here is a mixed-use village concept. And just want to add, our intention is to do a first-class community. We also aware this is an important property to the town and the entry district. We think the town needs more commercial spaces, certainly more apartments and rental units. And we think bringing tourism and economic, you know, it's going to bring more economic prosperity to Manteo. Thank you very much. And I'm here to answer any questions you may have, and Mike Schrader as well.
Does the board have any questions for Mr. Gupta?
I have a question. When you're talking about what kinds of businesses will be in that district, you keep talking about commercial. But Town Manager Melissa, for B3, isn't it just retail over mixed use? Yeah, retail over below, no, I guess it's below mixed use. Could you clarify with the B3 entrance?
Yes, ma'am. Section 9.2 dimensional, oh no, 9.3, I'm sorry. 9.5. 9.5 are special uses permitted by the town commissioners. Number 4 is mixed-use residential above retail, is what number 4 states, under the special uses permitted by you, the board.
And we have a definition of what retail is versus what commercial is?
I can check. commercial use is not defined in our definitions.
Is retail defined?
I'm working my way there.
Okay, sorry.
That's okay. You can't see my phone.
Melissa, Mayor Owens, I had a copy of the ordinance I brought with me. I was just showing Betty, I gave it to Jamie, is it fine if we all?
Don't address me, address you.
Oh, I was just talking to, okay. Could we hand them out just so everybody could see on paper the list of acceptable uses? Is that fine to pass that out in the class?
Of the special uses permitted by the Board of Commissioners?
Well, it's 9.5.
9.5?
section 9.5, yeah, just so we could see it in front of our eyes. I know we're in a
Is
plaza
the town
here.
clerk? Okay.
Is it legally acceptable?
That's fine.
Okay.
And Ms. Dickerson, I'd also note that 955 lists retail as a possible use separate from mixed use, and gives a number of examples.
Retail is not defined either.
But there
The-
are
yes.
examples of what that is.
Yes.
Can you read some of those?
Bear with me.
Did you say retail is not?
Or, and commercial, those are not included in our definitions.
Oh, Jamie's back with the copy.
Oh, good. That's helpful. Thanks.
Thanks, Jamie.
Number 5 says retail such as antiques, books, cameras, candy, clothing, craft goods, drugs, dry goods, flowers, gifts, hobby goods, jewelry, leather goods, magazines, musical instruments, notions, souvenirs, sporting goods, and toys.
And that's a such as. I guess the point is that, that what is permitted is mixed-use residential above retail or retail, which may be different than commercial. So I just want to make sure that there's clarity about what is possible in this district.
My understanding was that it was, you're right, because retail is a little bit more specific than commercial, my understanding. I know we had discussed this with our engineering firm, and my understanding was commercial was allowed on the ground level, but is it only limited to the retail of commercial?
That's
So I
my
just wanted to
understanding.
clarify that. I don't know if, so he's trying to look at it right now. So I know as a special use, maybe it's retail, but is commercial permitted in general on this property?
I agree with you on commercial mixture being more defined.
Yeah, I think the point of clarification, because you were using the term commercial over and over and over, that commercial had been approved, but nowhere in this ordinance does it mention commercial. I think it's an important
In the
note.
B3 entryway district?
That's correct.
Okay, I was not aware of that. I thought, Michael, do you have any comments on that, or? So is commercial allowed on this property?
Yes. Right?
My understanding was
I thought it was
allowed.
retail.
Okay, well, what's 9.2 about, Melissa? In the dimensional requirement, there's a section called commercial uses. Just want to
Yes,
clarify.
and so so commercial is allowed,
Okay.
but commercial has a different, has different dimensional requirements associated with it.
Right.
So there is an incentive in the ordinance with having the first floor retail with the second floor living space. You get an additional
15%.
lot coverage.
Right. And that's if with the entire first floor being commercial. Okay, so it does say language in 9.2, the entire first floor shall be commercial use, and that's tied to the incentive she's talking about.
I'm not sure about the rest of the board, how they feel about this, but I think, Manager Dickinson, we probably need a little more education on this. So I would like, more explanation of these ordinance. I wouldn't want to make a decision based on, just I need something more defined of what these ordinances and what can be used on that space underneath. How we do it, how we get there, I think it's another meeting with the board, because I want to know exactly what can go in there, what can't go up there, under that space.
Well, additionally, I think that that's not a bad point. I would like a little more clarification myself, and it sounds like that would be
If-
helpful to you as well.
Well, if it is retail specifically, that limits, I mean, we will abide by whatever is the rules around that. We can change that to retail if that can be a condition to understand that. But whatever is limiting within the town code, we will abide to that.
Assume that, the two buildings that you have just listed as commercial, what do you have in mind? I mean, I know you don't know anything exactly, but I mean, what do you have in mind for those buildings? Are they gonna be unfinished?
You mean the retail space?
The two buildings, G and F. You got one that's 11,000 square feet and one that's 7,800 square feet. And you just say first floor commercial, second floor commercial, third floor commercial in both buildings. And I think, and I don't know if I'm reading this right, but permitted uses as offices, including business, financial, governmental, medical, and professional, would I guess fit that? Is that correct?
Yes. I mean,
So I guess what there's a lot of, this is a big project for Manteo. And it's a big project for Manteo being the entrance to our town. And, I mean, we all understand the concerns of the people in the peninsula, like we all would be if we lived in there. Us as commissioners need to do what's best for the town residents, and that includes the peninsula. So, I mean, I agree with Betty, that, I mean, there's a lot in here that I think we need to button up before we can move forward, in my case, in approval. And I'm not saying denying it, but I just think there's some issues that you can probably address and get us one step further to possibly what you're wanting. But to me, if you have 11,000 plus 7,800 and you don't know what you're going to do with it, and all of a sudden these buildings don't rent, who's to say you're going to come back and say, look, they're not renting, I want approval for 22 more apartments or multifamily units? That could be a possibility. And so I'm saying, if this board has assurances what you're going to do with that space, and that's what I'm asking, do you have an idea on how you're going to go forward in filling those commercial spaces and filling them with what? I mean, if you do it with restaurants, I think that changes the parking. It also changes the whole dynamics of dumpsters and trash and smell. And that was another concern of mine, is where you have located these dumpsters next to your neighbors. I think that needs to be looked at and possibly relocated if that fits your plan. The traffic study, obviously that's number one, what everybody in this room is concerned about. I mean, we are down here every day. You're down here a lot, I know. But it's a bad situation. And that, to me, precedes everything on this table. And to make me feel comfortable in making a recommendation down the road, I would want a third-party traffic study. And I know DOT said, they would have to do it if you run that road from the highway to Russell Twyford. But I think this board needs the assurance of what that response is going to be. I mean, they could come back and say, yes, with the amount of units that are there, what he has proposed can work. But I want to see that. And I would recommend, I would suggest that this board would want to see this too, because this is a big project. I mean, it's a really big project. And I know you've got a lot invested in it, and I think there's always mediation, there's always ways to work things out. But we need to try to make your neighbors happy in the peninsula. We need to make the residents of Manteo, feel like they're getting represented, because everybody comes in that entrance around Napa, coming around that corner, and it's already, I mean, it's a mess. It's an absolute mess, and especially for the people who aren't from here, they don't know to keep going around that corner. They stop. And there's just a lot going on. And you've addressed that you would follow the Manteo way, which is assuring, because I know the park committee is an important part of this process, and I think they're gonna, make it look as presentable as it can from the highway when you're entering our town. We just got a banner out in the hallway that Melissa put up on the wall that Outer Banks' best neighborhood is Manteo. So we want to protect what we got. We want to work with you. That's your business development. But I think there's just some things on here that we're not engineers, but we can be guided and questions answered to help us better decide either adjustments, approval. But I mean, like I said, I think we can work with you, but I just feel like there's a lot of items that need to be answered first.
May I say some comments?
You may.
Thank you. I don't disagree with everything you're saying. I mean, you definitely have to, it's a big decision, and we can't take this lightly. I just want to emphasize that there's so many steps right now that are remaining. We're trying to get a SUP, and there's a complete site plan application, and we have to do architectural. There's a lot of state permits. The traffic study is about $20,000 on this. I'm trying to get to a certain point that we've already spent a lot of time and energy on this, that we can move forward with that investment right there. The traffic study, there's no way this is going to be built without you guys seeing a traffic study, agreeing into it. You can put more conditions on a site plan, and I mean, that's going to be part of this process, as is stormwater and many other things, as is the architecture. I don't know how to move forward with these things without getting to a certain point with a permit, some kind of approval to move forward. So I just, please do keep that into consideration, because this is a lot more steps involved in this right here. As far as the dumpsters that we have on there, I mean, we've tried to locate them in the best position we can. Staff has reviewed them. There was a comment made to make sure we properly buffer the landscape. There was no real requirement on the landscape on the Twyford side, and we had agreed to also do some extra landscaping on that. What the other comment that Melissa had made about the staff of the landscape plan, we had submitted a landscape plan, but the town staff wanted to see a similar landscape buffer that is currently in front of CVS. And that is what our engineer had added, pretty much the same buffer along on the highway there. Anyway, I just wanted to address those 2 points right there.
But one of my main points was you've got all that square footage of something you don't know what you're going to do with.
So, yes, I'm sorry, I missed that. So, yes, I have an idea of what, we were looking at doing, whether it's office space, whether it's additional growth from whether CSI or a doctor's office or professional space or an art studio. Before we go into and start designing those exactly, I have no way, we need some type of direction on this right here. Again, all this will come back. We do have some plans, but there's no way for me to say, so these shops exactly, here's what it is. What we want to do is really study what's missing in the town and put in things that would add value. Now, you mentioned that, okay, let's say if they don't lease, that's a risk that we take. And if we come back to ask for more, it's not something that's done by right. You would have to approve that. You would have to agree with that. It's not something I'm expecting, planning that, hey, we'll just go in. But I believe this area needs some commercial space. I think Manio's pretty maxed out downtown here. And as part of the BT entrant, it's really promoted to have commercial space, retail space, whatever the allowable things that we know was decided that's allowable. I haven't heard any feedback from the staff on commercial or retail on that, but we will be in conformance. I have no idea right now to say it's going to be these exact locations, but I've definitely considered it. And I see office spaces, I see retail, I see if it's some type of food, ice cream, restaurant, something, which I understand is permittable, but it takes more parking. So we're going to have to allocate a certain amount of parking to that. Right now, we do have additional parking spaces on this. I think it's like 20 or something additional parking spaces. So we may allocate an ice cream store or something else or whatever may be needed. Those are all things that I feel do come up as we proceed with the process.
I think during one of your comments with the planning board, you had brought up, or one of the members had brought up, short-term Airbnb. What's your, I mean, if you get them, you can do what pretty much you want with them. I mean, but just to let us know, I mean, is that one of your ideas? You might do a short-term rentals with some of those 22
Plan is to do
units?
longer-term rentals. I don't want to sit here and say that, you know, we're not limiting ourselves to that. This is going to be in costly development right here, and there's no restrictions that doesn't allow us to do something else seasonal. We're certainly not interested in putting a deed restriction on that. But I feel like the simple idea of condos, whether the long-term, short-term, I mean, that's, you know, that's the infrastructure that's needed. It's definitely not enough here. You know, our plan is to do longer term, maybe address some of the seasonal workers as well. If it's possible, maybe I could see a business renting out a condo and putting some people in there. It could be vacation rentals. Whatever we do, we wanted to do it higher end. So I do want to say that right there. This is not something that we're looking at a super affordable price point. You know, I still think it's needed in the area. We need to figure out a way. I don't know if the beach can accommodate it or this area or it has to go on the mainland, but this particular thing has gone now more into a higher end development is what we're proposing.
That's all I have.
Any other members of the board have any questions for Mr. Gupta?
I've just got a question. Talking about Airbnbs, Todd, I understand, I do not know because I do not approve of Airbnbs. I'll say it publicly. It brings a lot of stuff that's not good, and there's more Airbnbs in Manteo than you would even imagine. And I'm saying, are you against Airbnbs or for them? I don't know. But I wanted to address a little bit more up here. Unless the use is listed as prohibited, communication towers, restaurants with drive-through service is not permitted. But number 9, banks with or without drive-in windows is permitted. If a man wants to go put $1 million in, he can do it. But if he wants a ham sandwich, he can't get one. Explain that to me. Does it make sense? We got 17 things here that's listed that's legal, permitted. And it looks to me like it covers the whole gamut of anything you want to do. I'm not saying I'm for or against the project. I'm not committed to it. I'm like Betty, I think we ought to hold off maybe one more meeting, but we need to make a decision on this. This stuff has been going on a year or two. And we need to be fair to Summit, we need to be fair to Peninsula, and we need to find a balance, but we cannot keep putting it off and putting it off and putting it off. We've got to make a decision one way or the other. And if you're looking for me to make a decision, I'm not going to. But it seems to me like I heard Summit say he wanted to work with Manteo, and Manteo, I hope, wants to work with him to some degree, because we need housing. The biggest problem in Dare County today is not poverty. It's not racism. It's houses. We can't even house people that wants to come in here. What are we gonna do? I don't know. I wish I did. That's all I got to say. Anybody else?
Mayor, may I make a comment?
Go ahead. I reckon you better ask the attorney, don't ask me. I'm not in charge.
I see the idea of pushing this back another meeting. I'm not in a race, but I just don't know what that would do here. I don't see it as a requirement at this point. As a SUP, we're going to have to go through a lot of process, as I mentioned. I cannot tell you in a meeting that it's this door, this door, this door. You have permitted uses. I have to stay within the guidelines of that. So my only question is, I don't know what another meeting would do on this right here. I can't tell you it's going to be this door, but I can tell you that we will meet the ordinance, and we have to get to a certain point before we can go to the next step. That's the only thing I just please ask you to consider here. I know you will get a lot more information. This has to go through a whole process before it ever gets to construction. And I just don't know how to move forward or come in to start doing architecture and saying it's this store, or advertising, or putting it on the market to see who's interested in this right here. So I just don't know what I can get to you within the next month on this right here.
I think one thing that I hear, and I heard it from the planning board as well, is the traffic impact study is the thing that will inform us the most about the development there. I think without that essential piece, it's really hard to move forward.
Can it not be I think the staff was recommending it be a condition of the SUP. It's approved based on this traffic study and the findings of it. I can do the traffic study, spend money there, something else can come up. I just want to get an exact understanding of what, and if anybody in my position would be, I feel like we put a lot of time and energy into this. We've simplified it. There's 22 units. This has been a commercial property for a long time, and on the highway, and we're doing exactly what's in the B3 district. You guys have great questions. What is it going to be? I don't want to hide that. I just want to go. I also want to see if there's reasonable traffic conclusions that we can work towards. That is going to be just like there will be stormwater with the state, just like there would be water, just like there's going to be all types of stuff other than traffic that we have to account for. And I just request that it's a condition of this approval or whatever you guys decide here. But to go do that, I still, another question is what's going to go in there. So I just want to have a clear road in this right here.
I can't not think, however, that if you had had the study done, that might have informed what plan you would come asking for a special use permit. I know you're trying to do the right thing, but I think it feels like the cart before the horse somehow, not knowing that before a plan comes forward.
Okay.
And we don't know how the traffic study's gonna come out. It could say it's all right to do it, or this might be a very dangerous spot to do your development at. So you already have the SUP, you still can probably move forward with it. Our concern is the health and safety of our citizens and also the people who visit Manteo.
Well, I would agree to not only contingent upon a traffic study, but a traffic study and an overall development plan that the board is 100% satisfied with, that has covered it. So, we've designed something that is a lot less intensive than was previously. Went down to 22 units. I believe, again, we meet the code here. I believe the board can put conditions on this right here, and it's just hard, let's say let's say there's a traffic issue, then there's certain rework that has to happen. Ask, what does that mean? Does that mean we can't develop this property? This is forever not developable? Does this mean that, you know, I'm just trying to understand, how do we move forward right now? And I continue to spend time and money into this right here, and without a clear path, when there is a process here, we really stuck to the rules as we best understand them. It has been recommended for approval, contingent upon also, as part of the condition, a traffic study. You know, I just, again, respectfully ask that this will be a condition of the SUP. We will engage the traffic. It will be submitted to the town, and we will work through the findings of that. Thank you.
Any other board members have any questions for Mr. Gupta?
Yeah, I got one. I'm gonna say it. I shouldn't probably. You know, we seem to be hiding behind the traffic plan. And I can assure you this, all my experiences with state, federal, local government, we're a long way from getting anything from DOT. Oh, they can present it to the town, we can approve it, and I'll vote for flyover tomorrow morning, but you won't get it. Our traffic plan died when Mark Bassnight died. We were getting everything we wanted out here. Now we get nothing, and you're not going to get nothing either for a little while. So we can hide behind this traffic plan all we want to. What are we going to do?
I'd like to move to continue the quasi-judicial hearing on special use permit application for Salt Meadow Landing located at 0 Russell Twyford Road until the September 7th, 2022 Board of Commissioners meeting.
Motion's in order.
Second.
Second. Two seconds. All right, motion and second. We delay the plan until when? Saturday?
September 7th.
September the 7th, and can you, well, I'm not going to ask us to make a decision. I hope, let me add this. No, we got a motion. I can't do anything. There's a motion been made and seconded. All in favor of the motion, say aye.
Aye.
Opposed? Ayes have it. I hope we can come to some kind of resolvement one way or the other for this, because it cannot continue. And I think everybody in this room agrees with me. One way or the other, we got to make a decision. And I think I'm going to suggest that if the commissioners have any questions of any of these projects, we should have been more prepared tonight, I guess. We need to put something in writing and give to our town attorney that she can work with, and she can work with both sides, Peninsula and the Gupta Group, Saga Group. And we come to some kind of resolvement.
Well,
Okay.
I think some of the information just is, you saw.
It's there.
Well, but what I'm saying is, they had to pull all these back to redo some information that were in these packets. So I think some of it, you know, on Melissa's part, was she did not receive a lot of stuff until
Monday,
Agreed.
last
Yesterday.
minute. So,
Tuesday.
and Sumit, you know, I've known you, and we want to work with you, but it just, you know, I think there's things that you can do to help us make the right decision and also accomplish your goals as well with this. And like I said, I think the traffic study is one of them. And I know you said we could do that and, you know, work through that, but if we approve it tonight, you're going to start rolling, and for us to come back and give you a condition that it's not going to move forward because the traffic study now says they don't agree with it. I mean, what do we do? So I think if you take care of that now, and you're able to get something that this board can look at and satisfy us, the members of the community, and also the members of Peninsula, you know, you've bought the land. You should be allowed to develop what you want within reason. And that's why I'm saying I think there's a lot of mediation and give and take, but I think we can work it out. But I just think this board, this is a lot for us to look at and understand to make the right decision for the citizens of Manteo. So I hate to delay it one more time, but hopefully by the next meeting, you can take care of some of the loose ends. And one of the things is, you know, and I know it's hard for you to tell what you want in those two buildings that you're just saying is commercial. But I mean, commercial, you could put 15 offices in those things. I mean, you could generate, and depending on what kind of business it is, a ton of traffic. Or you could have just a dentist. You know, I mean, I don't know. It's open. But I think that's going to adjust, that's going to affect the whole traffic situation as well, depending on what goes in there. And trust me, I own a restaurant. But Manteo is in need of restaurants. And I'd be the first one at the door at night for dinner here or at Marsh's Light or wherever. I mean, because we are in desperate need of nighttime places to eat. And so, I mean, you know, we can work with each other and try to make it work. And like I said, I hate to delay it, but I just think we don't want to rush something this big and have our constituents upset with us just to get something rolling that we don't have our hands around. So just bear with us, try to get some of these things done by the next meeting, and hopefully we can find something that we can mediate and you can move ahead and we can too as well.
All right, what do we got to do, Ben, to close this out?
Wait,
I
please.
think you've made the motion to continue and voted on it.
Yeah, I have a comment.
You're at, oh,
Go ahead.
Okay. I just want to comment on this. So, obviously, this is a very large project. Probably all of us have been following it for a long time. I've prayed about it. I'm sure many other people have as well. At some point, I'd like to talk about green initiatives. I watch the planning board meetings as often as I can. They're vital for us to even, you know, be caught up at this point, to watch them online. So they had mentioned a charging station. Are you exploring any innovation here in the whole project? Because, you know, the traffic study thing keeps being brought up, DOT, whatever. You could go independent. You could hire Strong. Our consulting firm who sat here before us and presented our land use plan nodded at affirmation about how great Strong initiative is for planning. So you could go really innovative and come to us with, you know, gray water management, all kinds of things that completely blow our socks off. So, I mean, you are presenting us a big thing. This is a very big cake. It could be decorated really nicely. That would benefit the whole area. So just going forward, if you would consider maybe looking into some green initiatives, perhaps that'll come with conditions, but it's just, I want to put that out there, that there's a lot of innovation in what you're trying to do. So.
May I comment on that?
Sure, please.
I think it's a great idea. You know, as we look at development around the area as a whole, it's something definitely on our radar. And, you know, last 10, 15 years have been tough with the recession, and then it's COVID, and but we're in a place that we don't have a need to do this development. It can sit here for the next 10, 20 years. I want to do it. It's not just about maximizing ROI. It's, I would love to incorporate things that represents and does take development as a catalyst to, you know, for the next developer who's doing something. So it's very much on our mind. We are looking at charging stations. Again, we were trying to do some basic stuff that met the code right now. And then the idea is to certainly take it much further as we get into detail. There's a lot of stuff that we have to study and understand. But great point. And it is something that we are going to look at if we can move further into it.
Thank you. Just removing a heavy burden on the infrastructure will definitely be a little bit advising. So, thank you.
One comment, Mayor, and listen to Commissioner Clenso. Yeah, we're interested. We spend a lot of money, but I'm interested in the peninsula too. I know we all are, but we want to see how we can mediate, like some has already been said. So.
Anyone else? All right, do we have a motion on the floor to close the hearing out?
well, we've already continued it till September. We would
Okay.
restart it as an agenda item under old business, and we'd start it back with Mr. Gupta having an opportunity to continue his evidentiary presentation, and then the evidentiary hearing's still open.
But what I was getting at, we open up the conversation again, we're still all right.
it's already done, so
Okay.
I don't
Good
think
enough.
Mr. Gupta
Let's
had any
move on,
objection to
Melissa.
it.
Move on, Melissa.
Thank you very much.
Yes, Mr. Mayor. Item 7, new business, 7A, is appointment of a liaison to the Government Education Access Channels Committee.
I'll comment, this was a board that I sat on for about 6 years now. And just due to some scheduling conflicts, I'm not able to attend those meetings now. They're generally held on the 4th Wednesday each month at 3 o'clock at the county admin building. And there's a representative from each town that participates, as well as COA and the Dare County school system. If anybody else would like to attend those meetings and be our liaison.
All right, is the board prepared to make an appointment tonight?
I'll do it. Sounds cool to me. Is it cool, Eddie?
Yeah.
Go for it.
Sounds
You'd
cool.
be great for it.
Okay.
Sarah D., you're nominated.
Okay.
Sarah D.
My mom.
Ruth D.
It's all right, we're the same.
Sarah D. is her mother,
Yeah.
we're kin. How about any other recommendations, Ruth Stetson?
It's okay, if someone else wants to.
All right, can we have Ruth by acclamation? All right, you're it.
All right, thank you, guys.
Thank you, Ruth.
I look forward to it.
Okay, Mr. Mayor, item 8 on your agenda is old business. 8A is consideration of a Main Street liaison from the Board of Commissioners. And I'll note for you all that this would typically be an item that Michelle would present to you all, and she is actually en route to the Main Street Directors meeting in Elizabeth City. Their statewide meeting begins this evening, so she is not here. But as noted in the staff report, I have given you all, of course, the list of all the folks that you have appointed in the last couple of meetings to the new Main Street Committee, and now we're just looking for a board liaison.
Oh, Commissioner Webster, have you been a part of this?
I have, for, I think, most of the time that we've been meeting. And I do have a background in historic preservation, which was one of the aspects that the Main Street program looks for individuals to have. So, anyway.
I'd like to recommend we appoint Cheryl.
Second.
Third, great. Thank you. I appreciate
We'll have
that.
Cheryl by acclamation.
Yeah.
Yes.
Yes.
Thank
All right.
you.
It's happening, you're it.
Appreciate
And I
that.
think you're going to do a good job because you present a new face to the town of Manteo with new vision, and that's what we need. We need to get rid of the potholes and the lanterns. There's a lot of things we need to get rid of in Manteo.
There's potholes in front of your
Move
house.
forward.
That one's the worst.
I got potholes. There's potholes all over Manteo right now. I've talked to Melissa about that. All right, let's move on.
Okay. Item 8B under old business is consideration of the 2022 land use plan. This was a continuation at your July meeting. You all had held a public hearing and requested that this be considered at on this meeting agenda.
All right, any discussion?
I think it's a good plan. They put a lot of effort in it. And we needed to update it anyway, so. I move to approve the 2022 land use plan.
All right, there's a motion, is there a second to approve the 2022 land use plan?
Second.
Second, is a motion, second.
Could we have some discussion though?
Yeah, sure, always.
Is there any concerns that you have, Melissa, about it? I mean, are there any things that need to be polished or
Not at this point. I mean, our consulting group we've had many iterations and spreadsheets back and forth of edits that need to be made. I don't have any
okay.
particular issues. I will clarify, though, that this is just a local adoption, so this will come back to you all for a formal adoption. This is just so we can use this plan in the meantime. It still has to go to the Division of Coastal Management for approval, and we'll begin that process. But this just helps us be able to use the new land use plan for zoning determinations in the meantime. So if we find that there are other things we need to address when we go to do that more formal adoption later down the road, we can do that then.
Mayor, could I make one comment about the comprehensive plan? I feel so strongly that this is a really excellent plan. I've been involved in about 3 of them over the course of a couple of decades, and I think one of the reasons this one is so exceptional is that it represents the views of the residents, because there was such great effort made to capture what the people who live here really were looking for. And in that document, we can find direction. So I think it's a really wonderful product. Exceptional, actually.
I think this time we had more people too that participate in it, more citizens participate in it, so that makes it very special.
Yeah, agreed.
All right, anything else? All right, Mayor and Commissioner comments.
Let's vote on it. We got to
What?
vote on it.
What?
We got to vote on it. Yeah.
Oh, yeah, I thought we had to vote. Okay, I'm sorry, you're wrong.
I interrupted.
All right, it's been,
Okay, see.
we got to have a motion on the second on the 22 land use plan. All in favor, say aye.
Aye.
Opposed? Ayes have it. Motion carries. All right, Mayor's comments. I only have one. I'm going to back up what I just said. I will join any group that proposes a flyover down at Midway or any improvement to traffic considerations in Manteo and on 64. But it ain't going to happen. Get it?
I have none.
Ruth?
I'm not
I got it
quite.
right?
I'm not quite the pessimist. We may be related, but we disagree on that. I believe anything is possible. We call that naive, but I have hope and faith. It is a very complicated intersection, and it was heavily opposed in the current form it's in. Every option that was presented, I remember the process because my grandfather served on the planning board at the time when they were going through that. And when I got my driver's license, I made a left and went over the median, like a median that was there. I was so confused as a 16-year-old at this big new intersection in Dare County, which is tells you how small a town it is. But I think there are solutions. I think slowing down, just like our consultant nodded in affirmation, said it was a good idea. Nobody wants to slow down. I get it. I was passed on the road multiple times today. I'm slow. Slowing down is used worldwide. I think that we have to get aggressive in preserving the community we have. And I think whatever that means, we need to explore that. We need to be prayerful if you are so inclined. We need to talk to citizens because we're at a big crossroads. I will not hide that I am sad to see a giant housing complex go up at my entrance to my hometown that I love. He seems like a fine fella. I like development. I have developers in my family. I understand it, but the entrance has a special place in all of our hearts, and it's just gonna be an interesting transition. So I don't know what the future holds on that, but I ask that if you are a prayerful person or whatever you're so inclined, please pray for this board, pray for this community that we make good decisions. The legacy comment, that hits hard. It's hard to hear that. And I want to thank all those that are getting involved. We have an unbelievably active community that I had no idea about until I got here. I thought it was involved, but it's more involved than I even realized. I would love the planning board meetings. Hats off to those. This is a lot of homework, guys. This is so much homework. And it has to be done. I get why you have to have people that do it, but we need more eyes on it. That's why these emails are so useful, because it's great to see that other people are going through the stuff that we're looking through. So I just encourage everybody to continue helping. Help us with your opinions, your thoughts, and your expertise, because it's going to get challenging as a community as we divide probably over this issue.
That's all.
Dell?
On August 17th, the Pea Island Preservation Society will be presenting 2 programs at the North Carolina Aquarium for a national audience, telling the life and time of Richard Athers and his Pea Island crew at 12 and 2. So, anything to do, come show up and support us. Thank you.
Todd?
I feel for the people in the peninsula. But I think also, we just have to come to the realization that it's a piece of property that can be developed. Hopefully this board and your community and Summit, we can come up with something that'll work. It'll never be the pretty open field that it is now, but I think this board is going to try to do whatever we can to meet his needs and hopefully meet yours as well. The other thing I was going to ask is, I don't know what we need to do to move forward on Magnolia Market, but I know we've all talked about it, and we need to either have a public hearing, some ideas on what to do with it, if anything. I just think, as I said last time, it's such a special piece of property downtown, and right now it's just used as a shelter for kids and unfortunately homeless people. And I just think it's a special piece of property that we need to move forward with. Either tear it down, redo it, do something with it. I know there's a gentleman that had come to possibly put in a snack shop or something like that, but I think it deserves more than that. And I have said, Duck has done a wonderful job with their little downtown area with their amphitheater, but I think we could involve that plus other things. And I'm open to any ideas. I mean, to get Ben Cahoon or whoever to come up with some ideas to develop it. I just think we need to get it going. And I don't know what next steps we need to do that, but that would be what I'd recommend.
Excellent comments. Cheryl?
Yes. So I don't know that this will cure our transportation problems, but I did want to continue a conversation that we started a few months ago, and that's golf carts. And in fact, the mayor brought up the concept of the town allowing the use of golf carts for residents, as well as the possibility of renting them to visitors. So those were things that were just thrown out there. So in the spirit of really looking deeper into this issue, I have been reviewing a couple of golf cart ordinances from 2 different towns. One is Winterville, which is a small historic town near Greenville, and the other is Beaufort, North Carolina, which is a coastal town that attracts tourism. It's a tourist destination, as you all know. So these 2 towns were brought to my attention by Stuart, who did our comprehensive plan, because they said that these 2 towns really did golf carts successfully. And Winterville actually has been using golf carts for the past 12 years, I believe. So anyway, in comparing the ordinances of those 2 towns, there were a few things that I thought were interesting. I just wanted to throw these out just for food for thought. Of course, the number 1 concern of golf carts is public safety. And that golf carts in both of the ordinances had to have certain safety features: headlights, taillights, turn signals, and mirrors, etc. The other thing is that golf carts could not exceed certain speeds, which of course makes a lot of sense since they probably can't go that fast anyway. And in Winterville, the miles per hour were 25, no higher than that. And for Beaufort, it's 20. And of course, most of our streets are 20 miles per hour anyway. The operators of the golf carts had to be 16 years or older. And then for Winterville, one of the perspectives they had in their ordinance was that golf carts could only be driven from sunrise to sundown. They also said that golf carts can't be used on streets with posted speed limits greater than 35 miles an hour, and of course had to comply with traffic rules and adhere to traffic flow patterns. Nowhere could there be golf carts on sidewalks, which of course makes perfect sense. In both towns, the police department is the department that permitted, that provided permits to, for golf carts, and those were actually annually renewed. So and there were many other things. Those were just a cursory look at what golf carts are in other towns. So I guess I wanted to bring this up to see if we wanted to look greater into this question. Should we go to the next step and have Melissa write a draft ordinance, and then let's dig deep into that? What's your thoughts on this? I just didn't want it to lay there and not have us just forget about it, because honestly, when I am around town talking to folks, I've had a lot of positive comments about the use of golf carts. So I just wanted to bring it back to you all.
I've got a lot of positive comments too. People seem excited about golf carts. I don't know why.
I don't know how to handle this close on the comments, but I think it'd be order. I guess I knew what I pretty well want to, set the agenda, can I, Ben?
Yes, you could definitely set the agenda to talk about it, or
Can we discuss that right now temporarily, just a little bit?
Sure.
Under golf carts? Okay, let's open it for discussion right fast for golf carts and to Sherry's presentation.
I mean, I definitely don't have anything against them. I think they need to be, I know I think Nags had passed them, but I think they have to be licensed.
Street walk.
Absolutely.
Yeah, I mean, not just the police station writing you a permit. I mean, I think they need to be, I think, having a tag on them, a license tag.
And in both towns that I looked at the ordinance, they both were licensed. They both had to
I
have
think
licenses.
Wanchese even
And they had to
did.
have lights.
Didn't Wanchese do it?
Dare County did.
Okay.
Dare County did, and Ocracoke's got it, and it's a coming thing, and it's not unusual, and it's pretty neat, I think, but
Well, with our parking issues too, it would be,
there's no parking problems in Manteo, I've been told.
well,
Not after the
I know there's
town
not, but
That's what I was told.
it would even be better if you had a little cart I could slip right in. But no, I'd be open to,
All right, why don't we put it on the next meeting's agenda and discuss it, and we'll make a decision on it. Is that all right, Sheriff?
Sounds great to me.
Okay.
Mayor, can I
Melissa?
say one thing? I think it worked out real well July 4th. It was, the go-karts were very well used for July 4th. I mean, they rolled.
Very well used, well represented, I think Melissa will attest to that. Okay,
Good.
Eddie?
I've said this 100 times before, but I'll say it again, I appreciate everybody's interest here in the town of Manteo and all of your comments and concerns and how involved you all are. I greatly appreciate it. I also, probably sounds like I'm contradicting myself today, but I also appreciate economic interest in Manteo and outside interest in Manteo is nice to see as well. So I thank everybody for coming here.
Okay. Next meeting, recess meeting.
It'll be your September 7th meeting.
We don't have a, that's right, we don't have a meeting in August, do we?
we don't have a mid-month.
Yeah, that's what I said, I forgot, yeah.
That's
So
right.
we meet,
September 7th.
September 7th at 6:30. Can we have a motion to adjourn? Motion to adjourn is a second.
Second.
Motion and second that we adjourn. We stand adjourned until the next meeting in September.